She's still on KCBS from time to time in San Francisco. And over the weekend, we did a great show about the FISA
Oh,
reauthorization.
great. Yeah.
And it was Pat Thurston. It was so intelligent. It was both sides of the issue. We pointed out that Trump wanted to get rid of the provision of FISA, kill FISA, kill FISA. That had nothing to do with him. So it was actually very interesting that the far right and the left, the privacy advocates, almost made it required that they get a warrant. So, like right now, if your name shows up, Mark, because you're corresponding with somebody who turns out to be a foreign terrorist, they don't have to go get a warrant on you. Or if my phone number shows up and I'm in a conversation with someone who they think is with the oligarchs, they don't have to get a warrant, even though we're American citizens. And so they voted 212 to 212 with the far right, the left, the privacy advocates with the 212. And then the speaker, actually, he's in a lot of trouble today. And he's in good trouble, right? As John Lewis used to say, he's in good trouble because he's trying to help Ukraine survive this Russian onslaught. But the speaker actually voted against having to have a warrant. But when it comes up for reauthorization in 2 years, it looks like there will be a warrant requirement before they can investigate a U.S. citizen, even if the U.S. citizen turns out to be in communication, which may be totally innocent, with someone that the intelligence community believes is a foreign agent or a foreign terrorist even. But they should have to get a warrant before they scoop up our stuff from this enormous database that they're collecting all the time. That was the Patriot Act and all of that. So we had a very intelligent discussion about that, Mark, and she only has 5.5 minutes to do it now. But if you catch her show, she's on from time to time, KCBS in the Bay Area.
Jesus, enough about Pat Thurston already. Albert, what is the story with Katz talking about Pat Thurston? It's like
Albert, thank you.
It's like a love letter to Pat Thurston. I love her too, but I'm starting to turn on her just based
on
the amount of my
like
show
that,
that's
Mark.
taken up talking about her, Albert.
I might just clip that and send that to Pat, honestly.
Yeah, exactly.
There's never been anything like this.
Okay, I get it. She's great. I miss her. I tell we'll get her on as a guest. I've asked her. We were in touch. She is lovely, and I think honestly it makes me sad to. I don't want to say sad to hear her. I love hearing her always, but sad that she doesn't have more time on KCBS. So, David Katz, there's a lot to get to. Let's first of all talk about what's happening in this Trump trial with the jurors being plucked now out of the approval process and back and essentially for different reasons now being discarded from this jury pool. There's a lot here, actually, isn't there, David?
Well, yes, there's an awful lot here. And it's always been daunting, the idea of trying to get a really unbiased, impartial jury. The cynics always say that both sides want someone who's biased in their direction, who sees the world, through the perspective of their side of the case. Of course, the system wants to find as unbiased jurors as possible. And you want to try to ask those probing questions when you're one of the advocates that brings out for you or your jury consultants who you think are really going to be the good jurors for you, who get things from your point of view, who are going to be amenable to the defenses you put on, or if you're the prosecutor, to the prosecutive theory that you're putting on and that you have to prove beyond a reasonable doubt. And of course, since it's all out in the open, you hope that the answers and the vibes are ones that your opponent doesn't pick up and say, yeah, those are exactly the answers and the vibes that I don't want on the jury. So it's a very complicated process. There are people who hold themselves out as, jury consultants. I always thought I was very good at picking juries. I think I have, good people sense and a good sense of who I wanted on my jury. I sound like one of those radio ads, but I have the results to prove it. I've won an awful lot of cases on both sides. I won all my cases when I was a prosecutor, as you should hopefully win all your cases when you're a prosecutor. And I've won a lot of cases, outright acquittals and gotten cases dismissed as a criminal defense attorney. And that's hard to do.
To that point, David, you're saying, and a big part of that is figuring out who the best people to hear these facts and objectively evaluate them might be.
There are so many anecdotes. I won the acquittal of an attorney, and people said, "Oh my God, how did you get that client?" I said, "Well, when I was a law professor, he was one of my students." And they said, "I hope you weren't his professor of legal ethics." And I said, "I was, as a matter of fact, his professor of legal ethics." And in the fullness of time, he got indicted for income tax evasion, and I got him a total acquittal. And I can tell you a war story from that case. There was a banker who was a prospective juror, and he wanted him on the jury. He ended up acquitting along with everyone else. But I just thought, it's a reasonable doubt case. It's an emotional case. This guy who's so meticulous, he'll probably go through all the prosecution's evidence. He'll probably be the hardest juror to convince that there's reasonable doubt in the case. And I got proven right. And I've had hung juries, which is that's a victory for the criminal defendant. That would be a huge victory for Donald Trump if he had a hung jury at the end of all of this. That's also, people have different theories of who's going to hang the jury. The idea is you don't want very willful, strong-minded people on the jury. One of the things that's surprising about this current jury, at least as it now stands today, there are 5 members who've been picked and who've been kept so far, 5 only. 2 of them are attorneys. And the theory was always for the prosecution, you didn't want attorneys because they might tell the others, well, I know the law better than the judge. This is really stuff that I get. And they would be unmovable. They were just the kind who might hang the jury. And from a prosecutor's point of view, you don't think very much, well, I'm bringing a case that's going to end up being 10-2 or 9-3 for the defense. You're worried that there's going to be the 1 or 2 who's going to hang it. From your perspective as the prosecutor, 1 or 2 who aren't going to get it. They're just going to hate your star witness because maybe your star witness is a fellow criminal along with the defendant who's on trial. So there's all those kind of factors.
This is just on that point. John Watson asks, ask Mr. Katz if it's true lawyers don't like engineers on the jury. You were just speaking about having lawyers on the jury. What about engineers?
Criminal defense attorneys stereotypically don't want people in the exact sciences and don't want engineers. The idea is that they see the case very cut and dry. Now we're talking about the most stereotypical, hackneyed view of the jury, which is that the prosecutor is going to be arguing the evidence and, add it all up, 2 + 2 or 4, the defendant's guilty. And at least in the stereotype, that the defense attorney is hoping for sympathy, hoping for, other people didn't get treated the same as this defendant. He's had a really tough life. I just like him. He's handsome or good looking. Whatever it is that the defense hopes is going to be the hook, which is not a very straightforward view of the evidence only. That's the stereotype, at least. And so with the same stereotypes, you can go right down the list. I don't know, some of your viewers may not like it, but this was the old stereotypical list that goes back to, when I started doing this in the 80s as a prosecutor. And the list was that, you wanted, if you were the defense attorney, you wanted social workers, people with a big heart. You wanted women, generally speaking. Things could change about the case. You wanted people who were in the not exact sciences or in fields that were kind of a little, a touchy-feely, and that the prosecutor wanted the engineers. They wanted the men. In those stereotypical days, the prosecutor wanted Asian Americans, and the criminal defense attorney wanted Hispanic and African American jurors.
So that's the overview. Now, what looked to be a pretty quick impaneling of a jury. I mean, this looked to be something, you had 7 jurors as of Tuesday, and now we lose 2. Handicap a little bit for us how you see things proceeding. And the judge originally had mentioned that he wanted to, and indicated to both sides, they want to get things started on Monday. But they were click-clacking, but now they may be clicking, but not clacking.
They brought in 100 people. We call them prospective jurors or veneer persons. A veneer from the French, that they would come in and be called. Normally, if you say, well, I don't really feel that comfortable about this case, the judge wants to keep you around. But this is such an extraordinary case, such high profile, that if the prospective jurors said, I feel so biased, I don't want to be on this jury, that's called a hardship. Again, they're usually reluctant to let people get off for hardships unless they're real hardships and they're documented and probed. This judge just said, if you have a hardship, if you have a bias, you can get off the jury. So that they lost like 55 of the 100 people right off the bat. From the 45, yes, they got 5. So now they're going to bring in like another 100. And if history repeats itself, they'll go through that panel and get about 5, and they may have to bring in yet a third panel. So I see the chances of it actually starting with opening statements. I see that as very unlikely to happen by Monday. And I want to say one more thing about the case, because I think I have a sort of a fair-minded, objective view of it. And I think that this judge is making a big mistake by not excusing Trump. I think any day that Trump wants to be excused, he should be allowed to be excused. I think part of it is that Trump is, playing poker with the judge. And right now, I think he's winning. I think if the judge said to him, you can be excused any day that you want to be excused, I think he would turn around and say, oops, the judge called my bluff. I don't really want to be excused. He wants to confront Michael Cohen. He wants to confront Stormy Daniels if she testifies. He wants to be there when Hope Hicks testifies, when that guy Pecker from the National Enquirer. He wants to be there for so many of the witnesses. Watch this. If his son's high school graduation, which is so important to him, if he's allowed to go to it and Michael Cohen is on the stand that day, you watch and see which one Trump picks. But right now, Trump has the best of all worlds. He could say, this judge is pinning me down. Can you imagine? Texas might indict Biden tomorrow for some malarkey over the border. And some Texas judge says, well, under Texas law, Biden has to be here in my courtroom every single day. This is a criminal case. He can't be out campaigning. The world would lose its mind. And people should lose their mind a little bit that the judge is enforcing this rule. It may be a rule, but rules can be waived. Rules can be excused. He should let Trump go anywhere that Trump wants to go, any day that Trump wants to go there, and then Trump can make up his mind whether he wants to be in court or not. I think it's a huge mistake. I think Trump is not going to try to seek an order, because I think if Trump really wanted to fight it, and he really did fight it, the state court of appeal might rule in his favor that under these extraordinary circumstances where he's the presumptive nominee of one of our two major parties, he can't be pinned down in this way. This is starting to look like election interference, and not to me. I mean, I'm on the side of the prosecution in this case, but I think that's how it's playing. And the high school graduation, the judge should rule he can go to that. And if he wants to argue the case of his that's pending in the U.S. Supreme Court, I mean, it looks so arrogant. That's not a normal request. I have a case pending in the U.S. Supreme Court. I'd like to be there when this case that involves my presidential immunity is argued in the U.S. Supreme Court. Oh, well, you just want to be in another court. You're not required to be there. I think the judge is getting so played on this one.
That's really interesting. It's funny because I was mentioning yesterday that Trump is miserable right now because he is used to being able to have his way. He's used to being able to chirp up whenever he wants. He's being able, in most situations, to control the narrative. He is able to control the narrative outside the court, both before and after. But in that courtroom, he's forced to sit there and be quiet. He's even been reprimanded through lawyers about, speaking too loudly that might, with anything that might influence jurors. So I see him as in a miserable place. Now, you've just made, I think, a compelling argument for the fact that he is looking forward to confronting those who will be on the stand, those that you mentioned. But I'm wondering if there isn't an aspect of this which is, party's over, Donald Trump. You're going to sit here every day as long as this case is going on. And there's a punitive aspect to this, even as you make a great point about the fact that, well, he can claim that this is just that, a way to punish him, when it's actually not grounded in any sort of legitimacy.
And he's presumed not guilty. I mean, that's the great bulwark of our system. He's presumed not guilty. And I know that people really like the fact that he's, pinned down there. But he's gotten very good at getting himself unpinned down because they have that microphone for him outside the courtroom. No one seems to have turned that off. Maybe they think that's a violation of the First Amendment or something like that. But he goes right out there. He holds these press conferences. He dominates the news. Trump's, we've always thought that to run for president, you have to get a lot of good news. But Trump thinks a lot of news is good enough, that somehow a lot of news, a lot of publicity is good news for him. It shows that he's dominant. It shows that he's a player. You don't see Biden in the headlines on Monday, although Biden is the sitting president of the United States making major policy decisions. What do you see? And you may say, well, the thing is so tawdry, this is going to turn off the suburban housewives. Yes and no. It depends how things play. Not being allowed to go to my son's high school graduation. It's breaking my heart. That's going to hurt him with the suburban housewives. I know what the case is about. It's about a 15-year-old, a sexual peccadillo and paying off. I get it. It's falsifying records. It's a potential felony. But I think it can be cast as being a long time ago. And I think that the prosecution and the judge have to be very careful that they don't play into his hands, because I think so far, not as bad as they did in Atlanta playing into his hands, but they have to be thinking through that aspect of it. And I think it's very easy for the judges to say, I'm the judge, this is my courtroom, I'm used to giving orders, I'm going to be just like I always am, give orders and make people obey them. And he should look at the fact that, this is a whole different dynamic. You've just got to think outside the box if you're a judge or a prosecutor in this case.
I wonder, David, if it's notwithstanding what you just said, I mean, innocent until proven guilty, et cetera. Yeah, innocent until proven guilty. In other words, that's what the presumption is for everyone who is facing trial. Yet you're saying, but for this guy facing trial, we're not going to make him sit there the way you would everyone else who gets that presumption that Trump is getting. You're making an exception in his case. So the law already then is making an exception. It sounds to me like you're saying, yeah, and that's kind of what the law has to do and deal with some individual circumstance from time to time.
If a county near Eagle Pass charged Biden and Mayorkas tomorrow, with illegally transporting aliens into the United States by their willful indifference to it, and said, well, under Texas law, you have to sit here for your misdemeanor wobbler felony trial on those charges. And then Biden were required to sit there with Mayorkas day after day, because even though they're presumed innocent, that's the rule in Texas, and they got charged down in Texas, and they need to be in that courtroom. I mean, they just need to be there. And the trial's going to last, August and September. I don't know. I mean, what would you think of that? I know you're supposed to ask the question, not the other way around. But
that's why you're a great attorney. Now, I mean, no, it's because it's a legitimate question. It's not like you're just creating an argument. It's a legit argument. All right, so that's the situation in New York. Before I completely leave the situation in New York, because I have a lot going on at the Supreme Court, and I want to get to that. I know your time limited. I do want to, if you can just underscore something that's really important. The felony part of this is not the payoff. It's not even the falsifying records would be a misdemeanor, right? It's the falsifying records in service of covering up something that would be open to the general public then to make a decision in the general election on, right? I mean, that is to say for political reasons. Can you just take us, that linkage is super important, right?
This is a complicated part of it, and we've been talking about this really since the charges were first brought. So if he falsifies business records, and he knows that beyond a reasonable doubt, he knows he's putting down their legal expenses of $130,000, plus he's adding enough to pay tax on $130,000. And he knows that Michael Cohen has not performed $130,000 worth of legal services, with the hourly billing, $500 an hour. He worked for 260 hours. There's nothing like that. So he knows this is a fraud. It's still a misdemeanor unless it's in furtherance of some other crime, some felony crime. And one of the things that's remarkable about the case, because normally as a criminal defense attorney, I would have brought a motion for what we call a bill of particulars. I would say, you have to give me fair notice of what I have to defend at trial. You have to explain to me what it is that this other felony is. So far, the prosecutor has been able to not say clearly and not been required by the court to say clearly what this other felony is notice the crime that this falsification of records is in furtherance of that makes what Trump is charged with a felony. What is that other crime? So people have speculated that that's one of two other crimes, that he knew he was committing a federal campaign violation because it's a violation of federal campaign laws to not properly state what you're spending money on. And if you say, I spent $130,000 on Michael Cohen's legal services in the run up to the election, and what you spent the $130,000 on was a payoff so someone would hush up, that is a campaign violation. That could be the crime in furtherance of, which makes this a felony. But people say, well, wait a second, you're violating state law because you were going to make some federal felony. Wait, it should be state. So the people who say it should be state, which is the safer position for the appeal, as they win the case, Trump is convicted, it goes up on appeal, and they're arguing this on appeal. People think the better argument on appeal to sustain the conviction is that it's in furtherance of another state crime, which means that they're going to try to show, if they're smart, that Trump knew he was violating state campaign finance laws, that there's a law in New York State which says the same thing, that when you run for an office, and he is running for an office in New York because you have to win in New York to win the presidency. And so he knows that state campaign financing laws are being broken because they require the same truthful disclosures. And if they don't prove one of those two beyond a reasonable doubt, or they prove only the federal one, and the appeals court said, nah, not good enough, Then he ends up with only a misdemeanor, which will leave Trump with the argument, will it matter? We will have had the election by the time there's any appeal in this case, right? But it'll leave Trump with the argument if he's either only convicted of a misdemeanor, or he'll have the argument whatever happens, he'll say, they went to all this money, they went to all this expense, they made a mountain out of a molehill, this is a big traffic ticket. I don't see it that way. I think it's very important that people tell the truth on their campaign finance forms. That was John Edwards' undoing, that he had mischaracterized that money that he got when he was running. What was he running as then? I guess he was running for president. He was running for president,
exactly.
Yeah, and then he got prosecuted for that in federal court, and he ended up having a hung jury, and then the Department of Justice dropped the case. What's really interesting is that same kind of federal case could have been brought by the U.S. attorneys and by the Department of Justice. And there's been a lot of commentary about how it was slowed down. And there's no doubt about that. This is one of Bill Barr's ugly, ugly moments, how he slowed that case down when he was the attorney general for Trump, right? And remember, Trump was co-conspirator number one along with Michael Cohen, and then they changed the accusation around. There was a huge amount of political pressure. They de-emphasized that Trump was co-conspirator number one. They just said someone on the Trump team was co-conspirator number one. And one of the reasons that Michael Cohen is so furious is that he alone took the fall for this conspiracy that it sure looked like Donald Trump was part of and led and told Michael Cohen what to do. But when they report that huge delay under Barr, they do need to also report, Mark, in the interest of fairness, that the statute of limitations had not run when Merrick Garland became the attorney general. And when he appointed, right, and the president appointed a U.S. attorney for the Southern District of New York. And they, not Barr and Trump, decided not to go on this as a federal case. So that's part of the whole narrative, right, that Trump says that, hey, the feds didn't go on this. They went on Edwards and they didn't go on me. You see that even the feds knew it wasn't a federal crime. And that's why this DA is just making a big political hoop-de-doo after he ran on getting me. That's his narrative, right? I don't agree with that, but that's his story.
I feel as though that he'll spin no matter what. I mean, no matter what outcome, at whatever point, he'll always spin. Now let me just turn to the Supreme Court. There's so much going on there, and the J6 thing is, I suppose, a front and center argument and issue. And in early arguments, oral arguments, that's what we get a chance to hear. It seems as though the court, or you can tell me, it seems almost inclined to view these January 6th insurrectionists in a different way than the Justice Department has been viewing them.
Well, it's important to understand the statistics. Okay, so there's about 1,000 marauders, rioters at the Capitol. About 300 of them have been charged with this obstruction statute violation. 300. So to 700 of them, it doesn't matter. As to Trump, Trump is charged with 4 things. Only 2 of these, if the worst decision from the point of view of the Department of Justice comes down from the U.S. Supreme Court, it would at most affect 2 of the charges against Trump. So when he loses the presidential immunity argument, that's going to be heard later this month, which I believe he will lose. And when he goes to trial after that in the federal court in the District of Columbia, he'll still have at least 2 federal felony charges against him for what he did in January 6 riots. So this does not get Trump off the hook. And it might be that even these 2 of the 4 charges would still survive because Trump did a whole lot more in the January 6th, right? In terms of not tamping it down, in terms of the incendiary comments he made leading up to it. His particular motive may have actually been to destroy documents. He wanted to destroy those documents that came in from the states that showed that he'd lost. He wanted to reroute them or send them back to the states. But the problem with the obstruction charge, and there's about 100 people that this affects, and some of them, Mark, are charged with other things too. So there are under 100 people that.
But to be fair, David, they're under 100 people, but the penalties associated with this are substantial.
I think most of them are charged with federal felonies, Mark, where they would still face substantial penalties. You take Fisher, who's actually the appellant in the U.S. Supreme Court. Fisher himself, the former police officer, he's charged with 6 other crimes. In fact, Kavanaugh asked that question which he said, well, why do we need the seventh one so much? I mean, it's such a huge argument. Why even, why go down this road? And of course, the Department of Justice said, what do you mean? We go down this road because there's 7 good charges. We don't say, oh, well, one of them involves a legal issue. I mean, if it involves a losing legal issue, but if the government thinks it's a winning legal issue, they charge the 7th one. They don't just say, well, we're going to drop it because Kavanaugh may say you've got 6 other ones. So, they went back and forth on that. But this statute is a bit troubling because it was passed after Enron. It was passed because there was a loophole at the time that if you saw the feds were coming into your office, or you heard from someone, their feds are coming in tomorrow, and you destroyed the records yourself, you just threw a bunch of files in the garbage and burned them. You threw them in the fireplace and burned them. Or, you pushed delete, and you somehow actually managed to delete them, or you attempted to delete them. You were not guilty of a crime under that post-Enron period of time. So they passed this statute that said, if you destroy records or you otherwise obstruct justice. So it looks like they're going to say otherwise obstruct justice means you had to do something regarding records. So somebody who really went into the Capitol to try to destroy records, like to destroy the certifications of the vote or something like that. But someone who just went in there to maraud, obstruct justice with criminal intent, because that's what the government says. They said, well, we couldn't just convict everybody of this because you have to show corrupt intent and we have to prove it beyond a reasonable doubt. And they got questions, especially from people like Gorsuch and I think Alito, which said, wait a second, we're in the middle of our argument right now. Somebody jumped up in the middle of our argument here in the Supreme Court and screamed their head off and made a huge disturbance. And we couldn't actually decide the case today. It was such an uproar, we had to come back tomorrow. Could they be prosecuted for the same felony? Hadn't they just obstructed an official proceeding in the same way those people who marauded at the Capitol? And then the Department of Justice said, no, that what happened at the Capitol was completely different. It had to do with the peaceful transfer of power. There was nothing else like it. The reason that we're not going to charge this in the future because someone disrupts a Supreme Court argument or because somebody disrupted a council meeting is because it was sui generis. It was all different from everything else, what happened on January 6th. And, but I think if you want to do a Katz, I think they're going to say that it's too vague. They could charge anybody. Any obstruction is just too vague to hit someone with a felony and face, what is it, a 20-year penalty because you obstructed something. And of course, the super right wingers like Thomas said, well, weren't there a lot of other demonstrations? They want to go back to Portland. They want to go back to some of the excessive demonstrations, if you want to call that, after the George Floyd killing, right? And make the point that, well, how come you never charge this? And of course, the rebuttal mark is always the same, that this was one of a kind. You had 900 people and they got into the Capitol, right or wrong. They got into the Capitol. They did something which is, not going to happen even at the U.S. Supreme Court. So I think that they will knock down that statute. I think it may yet still apply to Trump. And no matter what, it doesn't spare Trump. Trump will face felony charges in federal court over what he did leading up to January 6th and what he did during January 6th, not tamping it down and sending an incendiary message about Mike Pence right in the middle of the riot when we all saw how dangerous the situation was on worldwide TV.
So well said. That seems like that is, oh, did I lose? Okay, there we go. No, there is a Katz with the prediction that SCOTUS will essentially let the obstruction skate, but that it won't affect future cases against Donald Trump. This from Maud. This is a $25 bond. Can't cover you, but I can, dear. Let me ask you about the bond. This is a little, then I'll jump back to the Supreme Court. Just Maud, and big shout out to Maud, always big supporter of ours. What about this bond company? There are increasing questions as to the story with this bond, David Katz. And several people have mentioned it in the chat.
Well, Maud has $25 of real money, apparently. And this bonding company out of California that's not even licensed in New York, where they're posting the bond, may have really no money. There's supposed to be a Schwab account that has $175 million in it. But I guess the concerns, the many concerns, the great concerns, are that it doesn't seem to be in the bonding company's name. It seems like it's still in Trump's name. And on top of that, is it pledged solely for this purpose? Or is it pledged so where basically the courts in New York have like a third or fourth on it? So someone has a prior claim on it, right? And so it's like, oops, 6 months into the appeal, someone made their write their principal claim on it, their primary claim on it, and the money's gone. You had asked me when this first came up, is there $175 million sitting in a bank that's secure and can't be touched or moved? And the answer seems to be no. So given that, I think the courts will reject that bond, maybe reject any bond from that bonding company, and go tell Trump to go get a better bond. And if he doesn't within, let's say, 10 or 12 days, go get the better bond, and it can actually be vetted and clears and looks like a real bond that'll be there to guarantee the payment of the judgment when Trump loses the appeal, then they can do all of the things to execute on the judgment that they could have. Whatever they could have done, taking the rents, going into Trump Tower, going into other properties, they'll be free to do that because we presume the regularity and legitimacy of judgments. And you can't just delay on appeal and keep your creditor hanging on. You've got to have a bond to either cover the creditor, or the creditor can start taking creditor's remedies, which can be going into your properties and seizing your rents and doing stuff like that. And I expect Letitia James, the Attorney General, will do that if a proper bond isn't posted promptly.
This from teacher Lori G, who asks, please ask about SCOTUS hearing on applying obstruction to January 6th insurrectionists. We did that. And Trump regarding the case about giving the prosecutors too much power in the current case regarding cop suit against BLM leader. That's another case, I believe, in which they rejected an appeal on the part of this Black Lives Matter activist, and they skipped completely deciding whether the leader can be sued for an injury to a police officer. Apparently, this was a protest in Baton Rouge in July of 2016 following the police killing of George Floyd. And this guy who faces a lawsuit from an officer who was hit in the head by a rock during this demonstration, or a piece of concrete, they're not sure. But anyway, the protest... Actually, I think the protest was sparked by the death of Alton Sterling, which happened outside a convenience store. But anyway, more to the point, the ACLU is involved and saying that the actions are protected by the Constitution's First Amendment, which guarantees free speech and the right to assemble, et cetera. And no justices dissented from the court's decision not to hear the case. But Sonia Sotomayor wrote a statement saying why the court did not need to intervene. She mentioned a recent Supreme Court ruling raising some of the same issues that could benefit this guy as litigation continues. The activist is DeRay McKesson. So I don't know if you want to comment on this. I guess she wanted to ask you about that, David. I mean, any thoughts?
Can we hold that thought to next week and have a chance to take a look at it and see what the issues are? Because it doesn't jump right into my mind what prior decision Justice Sotomayor is referring to. So
right. It's a little bit on the, but yeah, let's do that. I want to ask you about something that isn't related to SCOTUS. Well, somebody asked about Clarence Thomas. I mean, it seems obvious that this guy should have recused himself. He clearly has not from this J6 case. I mean, it's yet another reprehensible chapter in Clarence Thomas's career.
Well, it is reprehensible. He should have just recused himself from this case because it does involve the January 6th, riots. It involves these insurrections, and his own wife sent and reposted. I think she wrote some, from scratch, and she reposted some that were very incendiary in the same way that what these rioters did. I think she said something about, she reposted one that said, like, shouldn't Biden be in Guantanamo? And from all the appearances of this, all of the very far right-wing groups that she was involved with and so forth, her husband should have recused himself. Of course, he should have recused himself for many other cases too. And it just brings the Supreme Court into disrepute. I mean, it really does already. They say now that they want to buy him off the Supreme Court. They're going to give him like two of those fancy, not just one, but two of those fancy RVs that he drives.
I come from regular stock.
Yeah. They're gonna give him all those trips to somewhere that he went, that he blew $500,000 on the trip. They're gonna give him enough money to get him off the court. And just that people say, oh, is that really true? Did that happen? Are there documents that back that up? He so brought the U.S. Supreme Court into disrepute. And, all the judges in America have to live by rules, except the 9 on the U.S. Supreme Court. And the problem there is, of course, who would impose those rules and who would enforce those rules with a separation of power. And if somehow the judiciary did it, that would make the judges on that judiciary committee superior to the U.S. Supreme Court, right? Those judges could tell the Supreme Court justices what to do. It just seems to me that there's some solution to this, like a code of ethics that, more than 5 of the 9, right? A majority of the Supreme Court would impose these rules of ethics, and they would impose them on themselves. There's no problem then with the separation of powers. There's no problem with having a bunch of judges act in a way that's superior to the justices on the Supreme Court. The justices on the Supreme Court would do those things to themselves, which is exactly how it should be. They should have restraint. They should have the rule of law. They should impose those rules on themselves, and they should make sure that they get enforced, because whoever the enforcer would be would work for the U.S. Supreme Court. So there'd be no problem with the separation of powers. They just don't have the will to do it. We need checks and balances, and it's hard to put a check and balance on yourself, right? But that's the theory of our limited powers. People who are willing to submit to rules and have a rule-based system that applies to everybody, including U.S. Supreme Court justices. But the easy way would be is if they, the 9, would impose it on themselves.
Kim, did you have something?
Yeah, a story just came down today where Trump and his team are requesting a delay in the federal classified documents case or espionage case, saying that he and his lawyers really are only able to concentrate on the case going on in New York right now. And so I wonder, do these judges, is it reasonable? Do they have to act in a way that helps Trump and his lawyers juggle all these multiple cases in various states? Or is it, hey, your responsibility in this court is to this court. Well, I don't care what's going on anywhere else.
Generally, you have the right to your counsel of choice. But to say to the courts, my counsel of choice on this case is also my counsel of choice on my other case, which is also my counsel of choice on my third case, which means that my counsel of choice can't get ready by the deadlines that you set, is a loser. It's a little interesting, but it's a loser. The reality is that with Trump's money and his power, he can hire 4 different sets of great lawyers and have one set concentrate only on one of those cases. And again, for someone of limited means or middle-class person, that would be a totally different kettle of fish. But for someone like Trump, no, that your lawyer, that you chose the same lawyers for 2 cases, and so they ended up working on one and not the other, that's a loser. I think any judge would reject that. I think even Cannon would have to reject that. If Cannon gives them a continuance because they were too busy dealing with New York or dealing with the E. Jean Carroll case, civil case or something like that, they will finally get rid of her. That would be the ruling that undoes her in the 11th Circuit and gets her replaced with a different district judge. So, but at this point, they just file motions. They file motions. Some of it's for the base. Some of it is because you are entitled to file motions. I mean, he's the king of vexatious litigation. He really is. A lot of this is vexatious and frivolous. At the same time, as a criminal defense attorney, that's what judges do. They go through 10 arguments that may not be great because there's the one pearl, right? And we want that pearl to be heard in the interest of, better to have 10, guilty people go free than one innocent person go to jail. I don't think for a minute that Trump is innocent of any of those 4, but that's our rule of law. That's kind of the greatness of our system, that we do care about proof beyond a reasonable doubt, and every good motion should be heard and ruled on, and you have to go through a lot of chaff. And a lot of these just seem like chaff and not wheat in all
our last minute or two with David Katz. I just wanted to pass along questions that are coming in. Phineas asks, Mark, ask Katz if Palestinian protesters blocking traffic is a terrorist act. Well, they're not Palestinian. Oh, I guess they're protesting for the Palestinian causes. And Mama to 3 Boys says that's a great question. I was wondering the same thing. So is this blocking traffic, in this case it's Palestinian, but it could be anything. It could be PETA, it could be whatever. Is that a terrorist act?
I don't think that makes sense in these cases. You have to go through the particular facts of the case, but just the general act of blocking traffic. I know it's maddening, especially in LA. We have this thing which you can be for this, you can be against it, you can protest anything you want to. Don't block the traffic while you're doing it. So I
certainly get that
point of view. Yeah. Whatever your point of view is, however you want to express it, have your bullhorn, that's bad enough. Don't block the traffic, especially, we're so traffic. It's not like you could have much alternate. In the Bay Area, you kind of have alternate transportation.
Well, I don't know. You shut down the Golden Gate Bridge, which is what they did. I mean, that's really rough. And they shut down, I think prior to that, a couple of bridges as well. And in New York, they did the same thing.
Mark, one thing, let's bear in mind that some of the people who are getting on that bridge, they're going to surgery. They're going to some emergency procedure.
I made that point. I mean,
they're going to a job that they busted their ass to get, and they're going to lose that job because they got to work late. So let's not make light of the fact that, they do exact, a real, not trying to make a pun, they exact a real toll on people's lives to have the traffic suddenly blocked. There are other ways to protest. There really are. And that is a very selfish way to do it. Let's be honest. That doesn't make it a terrorist act, though.
Right.
As a matter of fact, we have a listener who was on her way to her very first oncology appointment, going to find out what the next step is to treat this thing she'd just been diagnosed with. A lot of people affected by this, and I wanted to mention that yesterday the CHP put out an alert in the Bay Area that anybody that was affected by the traffic stoppage on the Golden Gate Bridge due to that protest should call and give a statement to them. They may be able or eligible to get some type of victims' compensation money, and they're looking for information.
I don't mean that's such a great thank you, Kim, because that brings up another point that's just very legal, which is, can't I, on my way to my first oncology appointment or whatever it might be, my job, etc., can't I sue those who were detained for blocking the traffic, for the damages on my end?
They probably don't have much money.
Yeah, I mean, that's the reality, isn't it? Yeah.
There's that. I'm sorry, always bring it down to that level, but I'm a working lawyer. It's great to be with you, Mark, and great to be with Kim. So, play whatever theme your audience likes for me.
Welcome to Man Katz on the scene. He's breaking it down. Where's my Katzadamus? Where's my Katzadamus?
Known for the legal teacher in his drag. Oh yeah! Law in his hands, he's got the plan.
I'm loving it. There's Katzadamus. So good. David, thank you for being here. Love that you're here. And we look forward to next week. All the best,
See you
my
next
friend.
Thursday.
All right, I'll look forward to it. Thank you. David Katz, everybody.
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.